Showing on this episode of the program, a conversation about the just concluded elections and the role of the courts. We have the views of a senior advocate of Nigeria, Olukayode Eniitan. Also showing on the program, the Lagos State government begins the prosecution of Chrisland School, plus a recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shieli. The Department of State Services, DSS, on Wednesday raised the alarm that some politicians and their supporters are planning to force an interim government on the country. Is there any scenario where this is permissible under the country's laws? This was the first question I put to my guest, Olukayode Eniitan, SAN.
An interim government is an aberration and is totally alien to the Nigerian constitution. There is nowhere in that booklet, all the alterations that have been done, whatever amendments, there is nowhere we can situate such a thing other than to urge the DSS to proceed post-haste and arrest whoever they have identified as being involved in such aberrant thinking. There's no way to situate it. In fact, one can't be allowed to say that it is akin to urging an insurrection against the state, urging people to commence an insurrection against the state. So there's nowhere we can situate it.
I've heard some people say that because the process of elections was challenged before the final declaration of results, INEC was wrong to have returned the president-elect, and that perhaps that can be cured by putting in an interim arrangement, such as this interim government, while the petitions are being decided by the courts.
Such a person's learning definitely is not situated within the confines of the laws under which the Federation of Nigeria is being governed. We have an Electoral Act. We have a Constitution. These two documents govern what we do with regard to an election. First, the Constitution has stated how we are to bring in those who will lead us, whether as president, whether as governors, whether as legislators, whether even in the judiciary. It's clearly stated there. Now, there is an Electoral Act that has also stated what are the things that should happen. Those learned people, were they able to point you to any part of the Constitution or any part of the Electoral Act where they can situate such aberrant thinking? Once election has been held, except INEC declares it as inconclusive, someone must win. Whoever INEC finds to have won will be declared as elected. The one who has been declared to have lost then kickstarts under the Constitution and the Electoral Act the next steps. What are these next steps? He goes to the election tribunal to ventilate why he's saying that this person should not have been declared elected. If the tribunal agrees, they will remove the person. The minute the tribunal says, withdraw the certificate, and we've seen this happen time and time and time again, INEC doesn't waste time, withdraws the certificate. If the tribunal has says, hand it over to XYZ person, it is handed over. Now, the only thing is, where there are still appellate processes, they do not take it. They allow the process to run. Democracy is about a process from beginning to end. Everyone participating in an election must be willing, ready to follow that process through. Those who have contested any of the offices available under the Constitution are enabled by the Constitution and the Electoral Act to go to the tribunal. If you are not satisfied, and it is legislative houses, you know that you go to the Court of Appeal and that is the end. But if it is governorship, if it is presidential, it ends at the Supreme Court. Follow the process. There is no provision to truncate that process. There is no provision to deviate from that process.
But where do you stand on the debate that Section 134, subsection 2B of the Constitution has generated on the 25% requirement of the FCT?
It's unfortunate that for sometimes, either for personal reasons or for personal political reasons, or simply because people want to be mischievous, we keep bringing up issues that have been settled. And I think it's time that the courts even begin to damnify lawyers who bring up settled issues with a view to either by their weight or by the loudness of their voices to upturn it. The Constitution says the FCT shall be treated as any other state. That is simply to ensure that whatever the states have, like legislature, like courts, budgetary allocations and all of that, are also provisioned for the FCT. And the Supreme Court has decided this in one of the early Buhari cases. Now, it's to enable the FCT to have those things. It is not to give the FCT a status that is higher than those of the other states. Let's take this scenario. Someone contests to be president. He has majority of lawful votes cast. He also has 25% in 36 states. But for some reason, he has 10% of the votes cast in FCT. By this, our fantastic allocation of right and power to the FCT, that person will never become president because he did not score 25% in the FCT. It is humbug. It does not require esoteric reasoning.
So you are saying that that was not the intention?
That's not the intention. And then it accords with common sense. The man on the street who can understand English, it accords with common sense. Is there anywhere that the Constitution says that the FCT is bigger than any other state? So the proper interpretation is to say, look, FCT, take it like as a state, so you then say, oh, okay, that means there are 37 states. So the person must have geographical spread in, that would be 24, 25% in 24 states. Once he has that and he has the majority, he goes, regardless of what he has in FCT.
The judiciary has come under serious attacks from some politicians in recent times and even from some members of the legal profession over some of their recent verdicts, particularly on political cases. Do you think that these attacks are justified?
It's unfortunate that cases are not decided by the feeling of the judge. Cases are not decided based on the personal disposition of the judge. Cases are decided upon the facts presented to the court. Now, if you have presented a bad case, these are your facts, and you've presented a bad case, the judge cannot, based on his feelings or the fact that, oh, he would have loved to help you or he likes your face, he can't deliver judgment in your favor. It's going to be based on the facts and what the law says about those facts. So, I personally do not discuss judgments except I have read them. I will read the facts. I will read the pleadings as stated in the judgment, and then I will follow the reasoning of the judge or the justices in arriving at what decision they are handing down. When you do that painstakingly, and that's why we have the appellate process, where the trial judge is unable to properly grasp, he has one head, we are all limited. The matter goes before 3 people on appeal. 2 of them must agree. If 2 of them, and the 3 of them cannot disagree, it's not possible. So once 2 agrees, there is a decision. Oh, but the fact that 1 disagrees tells you that that point you can still push it further. At least you've got somebody who appreciates the point you're making. And then you go before a panel of 5. Now, that person who lost before the 1 head, who was able to convince another 1 head amongst 3 heads, gets before a panel of 5 and is able to present that singular point that he's been pushing and is able to convince 3 of those 5. They will overturn what has been said. But all of this cannot be based on anything other than the facts and what the law says about those facts. Too many of us, lawyers, sometimes comment without going through this painstaking process. More often than not, the public does not even understand, which is why you sometimes would hear people castigate judgments based on what they feel should have happened. But it is not about what you feel should have happened.
So you have confidence in the ability of the courts to do justice in the various petitions that have been put before them?
Definitely. Look, I'm a lawyer. I go to ventilate the grievances of clients. If I do not have confidence in the person I'm going to, I would go. I will not go. Now, those, of course, can our administration of justice ecosystem, are there things we can do to improve it? Oh, yes. But is that to say that, oh, no, I have no confidence? I have confidence in the judiciary. That's why I go to court every day. That's why I advise my clients, rather than ventilate your grievance by punching the other guy, go before the court. Go before the law. That is the beauty of democracy. We must continue to do that, because the more we go through this process of election, the more we ventilate grievances before the courts, the more we are strengthening our democracy.
Welcome back. The Lagos State government has arraigned Chrisland School Limited and some of its staff members over the death of 12-year-old student Whitney Omodeshola Adeniro, who died during the school's inter-house sport on the 9th of February 2023. They were all arraigned on Thursday before Justice Oyindamola Ogala of the Lagos High Court Ikeja on a 2-count charge of involuntary manslaughter and acting in a reckless and negligent manner that endangered her life. They pleaded not guilty. The Attorney General and Commissioner of Justice, Lagos State, Senior Advocate of Nigeria, Moyosore Onigbanjo, who led the prosecution on behalf of the state government, did not oppose the bail applications of the defendants, but urged the court to impose conditions that will guarantee that they show up for their trial. In her ruling, Justice Oyindamola Ogala granted the principal and vice principal of Chrisland School bail in the sum of 20 million naira each, with 2 sureties in like sum of 10 million naira each. The other 2 defendants were granted bail in the sum of 10 million naira each, with 2 sureties in like sum, pending the hearing and determination of the charge against them. The student was said to have slumped on February 9 during the inter-house sports organized by the school and held at the Agege Sports Stadium. She was given first aid by the nurse on standby and was subsequently rushed to Agege Central Hospital, where she was confirmed dead by the doctor on duty. A 9-page autopsy report conducted at the Lagos State University Teaching Hospital, LASUT, put the cause of death as asphyxia and electrocution.
The necessity of charging the school and the authorities is to send a message to everyone in the state that be you a school, be you a corporate organization, once you are involved with people gathering a large number of people at an event, at a function, you need to pay special attention to the safety of the people who will be at that function or that venue. It's very important because as we have seen in this case, negligent acts, whether you take an action or you refuse to take an action, can lead to fatalities.
We do not pray for anybody to lose a child. However, the reason why we are all here is to find the truth. What happened to that child? What led to the death of that child? That is why we are here. The child died at the stadium, not at the school. So we want to know about the facilities of the stadium, why the stadium should host an event, and why there should be death at the stadium. Again, we want to know about so many things that will help us to unravel the truth.
And just before we go, let's check out some of the top stories we tracked at the courts.
We begin with the report that the Supreme Court has dismissed an appeal filed by a former Minister of State for Education, Chukwuemeka Nwajuba, seeking to disqualify Bola Tinubu of the All Progressives Congress and Atiku Abubakar of the People's Democratic Party as presidential candidates of their political parties. The Apex Court dropped the suit on the ground that it was statute barred. Nwajuba and a civil society group challenged the nomination of Ahmed Bola Tinubu on the ground that he did not disclose the source of the funds which he paid to obtain the nomination, an expression of interest form in contravention of Section 90, subsection 3 of the Electoral Act 2022. He also argued that the APC did not comply with the federal character principle in the composition of its National Working Committee. The former minister had also asked the Supreme Court to cancel the process that produced Tinubu and Abubakar as candidates of their political parties. He had, however, lost at the Federal High Court and the Court of Appeal, both in Abuja, on the same ground that his case lacked merit. From the Supreme Court, we move to the Federal High Court in Abuja, where Justice James Omotosho has affirmed Victor Oye as the legitimate national chairman of the All Progressive Grand Alliance, APGA. In the suit brought before the court by APGA and Chekwas Okorie, Justice Omotosho held that from the judgment of the Court of Appeal, Kano Division, and later the Supreme Court, it is clear that there is no evidence that the judgment has been set aside. The court also held that the Supreme Court only made corrections in the typographical error made when Njoku's name was substituted with that of Oye, but upheld the decision of the lower court, which maintained that Oye was the validly elected candidate. APGA, Chekwas Okorie, and 2 others had approached the court to recognize them as the authentic faction of the party, having been produced by the Njoku-led National Working Committee. The judge, in dismissing the suit by Chekwas Okorie, the presidential candidate of the Njoku-led faction, said they lacked the legal rights to institute the case, having not participated in the exercise organized by the authentic party faction. Justice Omotosha further slammed a cost of 200,000 naira against the Njoku-led faction while admonishing his counsel for failing to act as minister in the Temple of Justice. The trial judge also held that Edozie Njoku tried to deceive the general public by misinterpreting the decision of the Apex Court and the Appellate Court in Kano. Staying at the Federal High Court Abuja, Justice Obiora Egwatu has dismissed a suit by the leader of the Islamic Movement of Nigeria, Sheikh Ibrahim El-Zakzaki, and his wife Zinat, in which they sought to compel the National Immigration Service to issue them international passports. In his judgment, Justice Egwatu held that the applicants did not provide sufficient evidence to show that their passports were either seized, destroyed, lost, or the relevant agency was unwilling to reissue them another one. Justice Egwatu held that from the position of the applicants, it was not shown that it was the Immigration Service who took their passports, but rather that the passports were destroyed or lost in 2015 when their residence was attacked by security operatives. He subsequently dismissed the suit. El-Zakzaki and wife had in January 2022 filed a fundamental rights enforcement suit against the Immigration Service and its Controller General for alleged refusal to issue new international passports to them. They asked the court to declare that the alleged refusal of the NIS to process their travel documents to enable them travel abroad for medical treatment was illegal, unconstitutional, null and void. Another judge of the court, Justice Zainab Abubakar, has granted bail to the publisher of an online news outlet, Cross River Watch, Mr. Agbajalingo, to the tune of 500,000 with one surety and like sum. Justice Abubakar had last Monday remanded Jalingo in prison after he was arraigned by the Nigerian police force for allegedly publishing a story that was considered an insult to Mrs. Elizabeth Ayade, who is the wife of the younger brother of Governor Ben Ayade of Cross River State. He was charged with offenses bordering on alleged cybercrime and was specifically accused of engaging in false publication that was intended to cause annoyance, ill will, and insult to Mrs. Ayade. However, he pleaded not guilty to the charge. Apart from the 500,000 naira bail bond, Justice Abubakar also held that the surety must be an owner of a landed property within the Federal Capital Territory. In Lagos, the Federal High Court has fixed April the 20th to rule on an application filed by the Kogi State seeking to vacate an interim order of the court, seizing 14 properties linked to the state governor. On February 22nd, the court had granted the interim forfeiture order following an ex parte motion to confiscate 14 properties and firms in Lagos, Abuja, and the United Arab Emirates, as well as 400 million naira recovered from one Aminu Falala. The Kogi State government, however, swiftly filed an application seeking to vacate the order of the court made on February the 22nd. Through their counsel, Senior Advocate of Nigeria Abdul Wahab Mohammed, the government argued that the order of the Kogi State High Court restraining EFCC from taking any step against the state government was still subsisting. He argued that in a federation, the EFCC lacked the power to dictate to a state how it spends money. Counsel to the EFCC, Rotimi Oyedekbo, in his response, said that the applicant had brought nothing before the court to convince the court to vacate the order. He urged the courts to dismiss the application seeking to vacate the order earlier made by the court. After listening to both parties, Justice Owewo fixed April the 20th for his ruling. And we round off with the report that the Independent Corrupt Practices and Other Related Offences Commission, ICPC, has arraigned a lecturer of the Tai Solaring University of Education for demanding sexual and monetary gratification from a female student of the institution. The defendant, Dr. Balogun Olaniran, was brought before Honorable Justice Oshinuga of the Ijebu-Ode High Court sitting in Ijebu-Ode, Ogun State by the ICPC on a one-count charge for violating Section 8, Subsection 1, Subsection A of the Corrupt Practices and Other Related Offences Act 2000. ICPC counsel told the court how the defendant, Dr. Olaniran, while being the head of the Department of Religious Studies at the TASUED sometime between October and November 2021, demanded for sexual benefit or the payment of 100,000 naira from a female student with a promise to alter her academic grades.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeat on air or watch via our YouTube channel. I'm Shola Shieli. See you next week.